Right. Ladies and gentlemen, colleagues, welcome to everybody who's joining us for this webinar, which is the first CGE meeting that I have the honour and opportunity to chair since my election as your new chairman, what I think all of about a week ago or 2 weeks ago now. And a special welcome to our visitors from the Society of Conservative Lawyers. Dominic just vanished from the screen when I mentioned the Society of Conservative Lawyers. That was not caught in effect. And can I say that it would be a great help in managing the discussion if everybody who has a question to submit could use, please, the Q&A function and not the chat facility. And then you will be asked to, you'll be invited to ask that question directly to Dominic. I ought to let everybody know that this webinar is being recorded. And now if I can introduce the panelists, and then what I shall do is hand over to Danny to sort of moderate the questions and to follow those up, and in effect to do an Andrew Neil act and interrogate Dominic. If we run out of questions, I shall use chairman's prerogative to ask some of my own. Daniel, I'm sure almost everybody who is dialed in will know, or if they don't know, will have read. He's a weekly columnist and associate editor for The Times. He's been with the paper since 2001, but before then he was an advisor to both John Major when he was Prime Minister and to William Hague when he was leader of the opposition. And Danny and I can remember, sort of burning the midnight oil, sort of drafting speeches which George Osborne used to pen, in coming up with some really pointed lines and some jokes that actually made people laugh, which is a real skill that very few people in politics actually have. He was appointed to the Lords in 2013 as a Conservative peer and named Political Commentator of the Year at the Editorial Intelligence Comment Awards in 2010, 2011, and 2013, and he's a former chair of Policy Exchange. Dominic, everybody I'm sure will know, the Member of Parliament for Beaconsfield from 1997 to 2019. And before that, of course, did distinguished service as the Conservative candidate for Lambeth Norwood in 1987, where he and I fought adjacent constituencies, which met in the centre of Brixton, which probably may suggest to you that neither of us was successful in being elected. He was Attorney General in the coalition government from 2010 to 2014, and in opposition he served both as Shadow Home Secretary and Shadow Justice Secretary. And of course, more recently, Dominic was chair of the Intelligence and Security Committee of Parliament and is the immediate past chairman of the Conservative Group for Europe. So, Daniel, can I hand over to you and ask you to take forward the first question, please?
Absolutely. So, good evening, Dominic. It's very nice to see you again and to have a chance to talk to you about your very interesting paper. We've long agreed broadly on this topic, but I think you brought out some new and important angles, and that's what I want to try and examine with you. Why don't we just begin by you rehearsing the sort of thrust of your paper?
I wrote the paper. Thank you, Danny, for coming on to this, and thank you to those from the Conservative Group for Europe and the Society of Conservative Lawyers, which I was once the chair of the executive committee, for joining in as well. I wasn't trying to escape them when my picture disappeared. Intention. I thought, let's do a review about the Conservatives and the ECHR and the HRA, because I think it's worth doing it, because this subject has rather dogged my career. Indeed, you could argue it probably contributed to its decline. I went into the House of Commons in 1997 and I made a maiden speech where I said I politely disagreed with the Conservative Party's then view that we shouldn't incorporate the ECHR into our own law, because I thought it was inevitable that we were going to have to do it. I then saw us hum and ha over the Labour bill on the HRA, which actually, at third reading, we abstained on, because Nick Lyle, who was the Shadow Attorney General at the time, thought that in fact it was the right thing to do. And then gradually I watched how during the course of the 90s, or the early 2000s rather, under the pressure of terrorism, Labour ceased really to be a proper supporter at government level of the HRA and the ECHR, and got into trouble with the courts on a whole range of human rights matters. And we gradually got to a point where David Cameron, who seemed to have become seized with a hostility to the ECHR, which was, I think, of long standing, and I felt at the time dated back to his time as a special advisor to Michael Howard,
Yes.
suddenly decided in 2006 that he had to do something about it, and announced he was going to scrap the HRA, replace it with a British Bill of Rights, and then handed it to me as the then Shadow Attorney General and said, would you please craft something? And I said, well, do you want it to be compatible with the ECHR or not? And after a bit of hesitation, it became clear that he would prefer if it were, but he wanted wriggle room so that we could wriggle out of bits of the ECHR if we wanted to, which I always said at the time was going to be extremely difficult. And since then, we've been through a series of iterations. We had a Conservative Party commission in 2008-10 that I chaired. There was then the Lee Lewis Commission, when there was the coalition government, which highlighted that devolution administrations were wholly against changing anything, that we couldn't do any change in Northern Ireland because of the Good Friday Agreement, and we had to remain adherent to the ECHR and have something very similar to the HRA, if not the HRA itself. And yet we kept on coming back and saying, we're going to do something. And indeed, it's probably the reason why I ceased to be Attorney General, because Cameron wanted to put into the 2015 Conservative Manifesto a thing about scrapping the Human Rights Act, replacing it with a British Bill of Rights, which could be incompatible with the ECHR, and threatening to leave the ECHR if, in fact, incompatibility resulted, so that we were in a conflict with the court in Strasbourg. But actually, because there had been some opinion polling done by Linton Crosby, I think before the 2015 election, about whether people were really interested in this, they found actually that only 16% of people were. So it appeared at page 92, or somewhere deep within the manifesto. And in fact, thereafter, despite successive Lord Chancellors, Liz Truss saying that something was going to be done, nothing has actually happened. And the purpose of this paper was to explain that the reason why nothing has happened is because, in my opinion, although the ECHR may be far from perfect, actually the benefits of adhering to it and being a participating member of the Council of Europe and promoting human rights on the global stage vastly outweighs the pinprick irritations which the HRA and the ECHR produce. And I further attempt to demonstrate further the good it's doing on the continent, and the fact that most of the irritations that we were concerned about have largely been resolved by the Brighton Declaration, was part of it, which I did with Ken Clarke in 2012, which set the Court of Human Rights on a new direction where it's actually not spending very much time worrying about the UK at all, and has filtered out its cases much better. And I might add also David Lidington's doing in having resolved the problem over prisoner voting in Hurst, the Hurst judgment. And actually, we succeeded in doing that at the end of the day without any primary legislation of any kind at all. So I suppose my theme is, why are we getting still so worked up about it in some sections of the Conservative Party? And would it not be better to just try to make it work better by being active players in the Council of Europe, which is now going to be quite an important forum for us now that we've left the EU? So in a nutshell, that's what I was setting out to do.
Thank you. The Conservative Manifesto, of course, now has this very unclear statement that we're going to try to revise the Human Rights Act in line with the ECHR. Is that actually possible? I mean, how could you do that?
Well, I don't think it's easy to do. I highlighted, I think, in 2008-10, that there may be fractional areas of wriggle room where you can have a Bill of Rights, British Bill of Rights, with the same rights as in the ECHR, but possibly a slant of interpretation that is slightly different. We already have that, for example, in the fact that the HRA interprets the right of privacy and the right of freedom of expression marginally differently, or places an emphasis that might be slightly different, but within our national tradition. Nothing wrong in that. But once you start getting to what I call the fundamentals, can we deport somebody to a place where they risk being tortured, for example, in breach of Article 3? The answer is very simply, you can't do it. And if you try to do it, you're going to come unstuck. So it would be much better, I think, to accept that. Obviously, if the government wants a British Bill of Rights, it could have it. And that Bill of Rights could put in rights that currently the European Convention on Human Rights doesn't touch upon, which might be seen as being more British or English, or at least, within our national tradition. We could try to work out a more detailed privacy law and the right of freedom of expression for the press, just about. But there's not much more that you can actually do. And if you don't want to do that, then actually the Human Rights Act is a minimalist incorporation of the convention, and I think is showing itself to be working fairly well.
Okay, well, let's examine the critique of the Human Rights Act in two parts. So I want to talk about the idea of judge-made law, and then we'll go on to the question of sovereignty in a second. Now, obviously, the issue of judge-made law isn't much of a critique when made by a party that wants to put in place its own Bill of Rights. But nevertheless, that is definitely part of the criticism, and it may be that when this government gets round to tackling this issue, it decides not to bring that proposal back at all, just wants to not have such a thing. So let's just examine the whole critique of judge-made law. And I suppose the best way of asking this is to ask whether you listened to Jonathan Sumption's Reith lectures and what you thought of them.
I did listen to Jonathan Sumption's Reith lectures, and I thought they were a very good critique of the risks that come from an excessive amount of judge-made law. And I don't actually disagree with him. But it's interesting that he's often prayed in aid on this issue, but if you look at what he said and what he said subsequently, he was producing a critique. He certainly wasn't saying that the solution was pulling out of the European Convention on Human Rights, or so altering the Human Rights Act that we would be incompatible with it. I think he was expressing some concern, which had been expressed previously by a series of distinguished judges. I think it started with Lord Hoffman back in about 2010, 2011, when he said there's a risk that the European Convention on Human Rights and its interpretation both nationally and by the court in Strasbourg, the Court of Human Rights, is at risk of pitching itself into confrontation with elected representatives. And there is a limit to what judges can or should do in this field, and they should be very respectful of different national traditions. And he pointed out that he thought what was called the margin of appreciation, which is your ability to deviate from another country's interpretation of the convention, that margin of appreciation was being narrowed down excessively and was beginning to cause problems. And the classic example of that is actually the Hearst judgment on prisoner voting. But there are others. And he did that. And I think his critique was correct. And he also made the correct critique that the problem is that judge-made law tends to be quite binary in character. And whilst it may be cerebral, it may not reflect the chaotic compromises which sometimes have to be made in the political sphere. So I don't disagree with that critique, but at the end of the day, it still chucks you back on the issue. If you're going to remain adherent to the convention, you've got to try to change the way the convention is interpreted by influence within the Council of Europe, which is actually what we have been trying to do quite successfully over a 5, 6, 7 year period. Or if you pull out, you've got to take the consequences. Whereas I come back to my original point, I think that the consequences in deleterious terms, vastly outweigh any possible benefit we could get from doing it.
If you were to be appointed to the US Supreme Court, obviously very likely to happen, would you be a strict constructionist, or would you be a progressive justice?
I think I would probably be a progressive justice, but I think we need to be a little bit careful here, because this is an area where US legal interpretation may have diverged from the way in which I think our own national courts interpret law. Let's leave the European Convention on Human Rights out of it for a moment. Do we have judge-made law in this country? Yes, we do. Why do we have judge-made law? Firstly, because when it comes to the common law, which has of course never been written down in statutory form, but is previous interpretation, judges vary that interpretation to meet new circumstances. And indeed, occasionally, it's alleged against them, and I don't think improperly, they create something which is quite unusually new. I mean, let's take one example. It was a rule of the common law that a husband couldn't rape his wife. And that had been the rule of the common law for at least 300 years, since somebody had first raised it as an issue. And the House of Lords, I can't remember when it was now, but it's 20-something years ago, just suddenly said, we don't consider that this rule of the common law has any relevance to modern circumstance, and we think it's wrong. And they changed it. There was no legislation, there was nothing. It just changed. And I think most people would say that the idea that a husband cannot rape his wife is fundamentally wrong, if in fact rape has taken place and sexual intercourse has been forced. So there's one example. The other example is about the interpretation of statutes. Statutes are drafted so that they often reflect circumstance at the time they take place. So you can have a statute that's drafted which refers to, and we've had an example of this, to a husband or a wife, and subsequently it's held to extend 40, 50 years later to a same-sex partner. And that's because the judges have said, well, if to make this statute work in the current circumstances, you have got to have regard to the fact that we now have same-sex partners, and this is what this is about, family relationships and family law. It should be changed, and it doesn't need Parliament to enact that. Now, I think in the United States, they're much more hesitant about doing this. And of course, that also goes back to the whole issue of the European Convention on Human Rights. If indeed it is a treaty which is set in the concrete of 1950, then undoubtedly the court has been interpreting it in ways that were probably not envisaged by the people who signed up to it. But then changes, such as, for example, the ending of corporal punishment, the right to beat children in schools, the law which says that you've got to have same-sex partnerships if you're going to have, you've got to include same-sex marriage if you're going to change your marriage laws. All these things would never have happened. So you have to make a choice, and I'm not sure which is the better. I think if we'd had it stuck in the concrete of 1950, then it would either have to have been revised every 5 years as an international treaty, or it would become pretty useless. And there are plenty of other examples as well.
Okay, so once one comes to the conclusion that it's a good idea to entrench rights, you then conclude that judges have got to interpret those rights, but that will not be mere strict constructionism, it will develop. That's clearly a political role in one way or another. Do you take the view that this need play a role in the selection of judges? I'm here talking, we'll come to this, the European Court of Human Rights in a second, but let's just deal with our own Supreme Court, where I've taken the view that perhaps it would be a good idea to have hearings that didn't have a vote at the end of them, but just merely discussed the judicial philosophy of the appointee, so that we had more of a public discussion? Or do you think that would be dangerous?
I find it difficult. I certainly can see that there might be some point in having judges come in front of a committee without it being determinative, if they're being appointed to very senior appointments like the Supreme Court. I suspect it's really probably just the Supreme Court. I mean, I know you could start arguing you want to do it the appointee for the Lord Chief Justice, but I think I might probably stick to the Supreme Court to come along and just have a discussion. But it's inevitable that the individual concerned is going to have to be very guarded. And I think that the risk I can see is that they are being pilloried for expressions of view they may have made even prior to them becoming judges. Whereas on the whole, the evidence of our judiciary is that they don't bring their own personal views into being judges. They actually go on the bench and interpret the law as best they can. I certainly don't want to see the US model, which I think has been immensely damaging to the United States. Even though for the Supreme Court it's inevitable, but I mean the worst part of the US is the elected judiciary, which I think is undermines their rule of law in a way that is quite frightening, because actually judges are ultimately almost electorally answerable in many cases in parts of the US to an electorate, and it's not a good thing.
Okay, so I'm doing this, you understand, to sort of scope out your thinking, even though some of it isn't directly in the paper, because I wanted then to move on to the next question, which was the question of sovereignty, which is obviously at the bottom of this. If one accepts, and weirdly enough, I think the government would go along with almost every step you've taken so far. Maybe not, some of them would be strict constructionists, some of them wouldn't be, but then the departure point is whether or not that is a power that a, in quotation marks, foreign court should have. What is your response to the idea that, well, let's first of all take this. Do you think the European Court of Human Rights is a good court?
I think by the standards of international courts of justice, yes, I think it's pretty good, actually. Certainly much better now. It's as so often happened, it's had its ups and downs, and I'm not saying that every judge who has been nominated by one of the nations that is a signatory has always necessarily been as good as one would wish. But on the whole, the overall standard has struck me as being pretty good. I've always found it a more, I'd say as having a practitioner, a more interesting court to appear in front of than the Court of Justice in Luxembourg, which was a rather different entity altogether. Now, as to the point you raise about sovereignty, there is no direct effect of any judgment of the European Court of Human Rights. That's why, of course, the Hearst judgment went unenforced for nearly 10 years before our chairman found a way out of it, which resolved the matter. And as I've said on many occasions, I happen to think the court got the Hearst judgment wrong. I just think I can understand where they were coming from, but they were trying to impose a level of uniformity on the whole of Europe, which I think was unnecessary, but probably reflected some of the anxieties it had about countries which were now members of the Council of Europe, which had very shaky human rights records. But it doesn't have direct effect. It's a treaty obligation. Does that matter? Well, if really we're getting totally hung up on sovereignty, I think it's worth pointing out that we are signatories to about 14,000 international treaties, about 800 of which have arbitral mechanisms for resolving disputes over definition. And actually, the Court of Human Rights in Strasbourg is in practice, or in theory and practice, no different. You sign up to a treaty and there is an arbitral mechanism for resolving interpretative issues. And this can range from the law of the sea, where I appeared once on behalf of the UK government against the government of Mauritius over the British Indian Ocean territories, and we got a judgment which we didn't much care for, but which we have said that we will observe. because we set it up. And there are a host of others which also apply. International Court of Justice is obviously one of them. So why is there this particular sovereignty hang-up over human rights? I'm never been totally clear in my mind as to what the issue is. I realise that it touches on areas of government action which in the past governments took without actually any regard for any likely judicial inhibition, but where actually in modern society, most mature democracies accept that there is going to be some judicial input. Why should we be so bothered that that comes from the European Court of Human Rights? And I think I'm right in saying that last year, I think there were only 3 judgments against the United Kingdom, which were of an operative character.
Okay, so we've sort of scoped out the argument. Now comes the difficult bit, which is trying to win the political battle. The main way that this political battle has been won so far is that the idea has been so flawed that nobody has been able to do it, because they want to remain inside the ECHR, keep a Bill of Rights, but not actually and change the Bill of Rights without producing incompatibility with the ECHR. And this proves to be trying to square a circle, and it hasn't been possible. So it is possible that at some point somebody breaks this and just simply says either we'll leave the ECHR or we won't have or both, that and we will not have a British Bill of Rights at all. It may be that they don't have a parliamentary majority even at 80 seats to win that, but it may be that they do. What is your thought about how to win this argument?
I think the argument needs to be one on the positives that flow from both the Human Rights Act and the European Convention on Human Rights. And the positives are not just for us. I mean, the reason why we signed up to it in the first place, I have no doubt in 1950, most people in the UK thought that our freedom under law, an unwritten constitution, was infinitely superior to every continental model in existence, and felt that our traditions of liberty were much better than those in countries like France or Belgium or Italy, where the state intervened much more. So in fact, this was our gift to our European partners. This was our standards being converted into a written document, which was then being provided to them, which would enable them and their citizens to enjoy liberties that we took for granted. And I don't really think that that has changed very much. The only thing is, as time went on, we discovered that some of the liberties we took for granted were perhaps rather less well protected than people had appreciated, and started to either value or get irritated with court judgments against the United Kingdom. But if we go, we lose that soft power influence. We'll be out of it. The ECHR will doubtless continue, but our influence will be gone. And we'll also have to leave the Council of Europe, which, although it is an organisation which was eclipsed very quickly by the arrival of the EEC, does remain as the only major forum for bringing European countries together to discuss issues of liberty, human rights, and justice cooperation. That's going to be quite a blow to us. It's a form of isolationism, which I think we will pay quite a reputational price for. So I would go for that as my argument for not interfering with it. And then I would reverse it and say, what is the benefit that you actually think in practice you are going to get by leaving and having a British Bill of Rights, which ultimately stops with the Supreme Court? The Supreme Court, if it's a Bill of Rights, will still do the same thing. Of course, you can always disregard it because the Bill of Rights will presumably have a declaration of incompatibility for primary legislation. But we'll still have the possibility of confrontation between judges and the government, unless, of course, you intend to remove the power to make a declaration of incompatibility completely, in which case you might as well not have a Human Rights Act or Bill of Rights at all.
We're going to go now to some questions which I'm going to call upon our participants to give, and I thought I might ask Keith best. I have a question here, Keith, but why don't you come online and do it yourself?
Well, thank you very much indeed. Well, it's very nice to be with three of my political heroes. And it's been very interesting to not only to read Dominic's paper, but also to hear what he has to say about it. And of course, David's been very directly involved in this, the Ministry of Justice. I mean, my question is simply this, that as Dominic already said a moment ago, I mean, none of the Strasbourg Court's judgments are binding on the UK. And yet, almost invariably, and I think maybe invariably, although it's taken some time, as with prisoners' rights, and 10 years to do it, British governments have complied with those judgments. I'm sorry, David, I did say it was somewhat curmudgeonly in the case of the prisoners' rights, that it did so, but I take Dominic's point about really a misunderstanding about the ability or the desire to impose a uniformity, which probably wasn't really a sensible thing for the Strasbourg Court to do. So my question is, why, when there is clearly some degree of antipathy in high political circles towards this treaty that we belong to and the judgments that we get from Strasbourg, why is it that governments have found themselves so adept at compliance with those judgments? Why haven't they tried to make an issue of non-compliance in order to try to force the matter more into the public domain and to get debate? And although I say this with my tongue in cheek, because I realize you cannot bind a supreme legislature, does this not in its own way rather set a precedent, which might it be a nice idea if it could be construed as binding?
The reason why we eventually comply is because the UK keeps on saying that we believe in a rules-based international system. Indeed, Dominic Raab seems to say this almost every day of the week, and I heartily applaud it. And as he was my past chief of staff, it's a subject on which I know I agree 100% with him. But if you're going to have a rules-based international system, you have got to obey the rules. And if you sign up to an international treaty, you have got to accept the consequences of it. Now, people may not all be aware, but what happens if there's a judgment of the Court of Human Rights? The implementation is sent to the Council of Ministers, which is a group of ministers, usually justice ministers, who meet and who review the judgments and whether in fact they have been responded to. So there's quite a lot of peer group pressure, because when a UK minister goes over to these, I can't remember if the meetings take place every 6 months or every 12 months for the review, they'll be nudged and said, well, what's going on here, by their peers. So, and at the same time, of course, they will be reviewing the failure of countries like Russia, Romania, Ukraine, Turkey, often to implement judgments, and a very large number of them, many of which are about quite serious violations of human rights. So the pressure is a bit on a country like the United Kingdom to show that if this treaty is to have any meaning, we observe its terms. And as you'll be aware, the ministerial code, which the Attorney General is supposed to be a great upholder of, used to expressly say that the United Kingdom, its civil servants and ministers, will observe the United Kingdom's international obligations, which includes implementing judgments of the European Court of Human Rights, although you can delay a bit. You can hope there might be another case that comes up which might lead to a review, or you can hope that a sensible Lord Chancellor like David Lidington comes along and finds a solution to your problem. But at the end of the day, you're going to have to do something about it. Either that, or we don't believe in the rules-based international system, which we have been the principal nation state in creating. I don't suppose any country in global history has ever signed more treaties than the UK. And we did it at the height of our imperial glory as well.
Thank you very much, Keith.
Thank you.
And
thank you.
Thank you for your question. I'm going to ask a question that was asked anonymously, Dominic, so I'll read it out. If the government decides to bring a vote on the ECHR, how do you predict such a vote will go in the Commons with its large majority, but also the Lords? But I think the Lords is easy to judge, to guess.
I agree.
Let's talk about.
I don't know how it would go in the Commons, because there is quite a lot of ambivalence, and I don't obviously know much about the 109 new Conservative MPs and what their views will be. My experience was that Conservative Party views on this were much more nuanced than people appreciated. One of the difficulties is that we got ourselves into a situation where if you had a party conference or a party meeting and you stood up and said, scrap the Human Rights Act, you'd get an immediate massive round of applause from the audience. If you then actually had a discussion with them about what this was all about, you'd often find that people's opinion would change. And I don't know, I'd be interested, in others participating this evening may have a much better idea of the extent to which mail bags of Conservative MPs are full of imprecations against the Human Rights Act and the European Convention on Human Rights. My impression of the last 3 years was almost zero.
Yeah.
But I can see that you can have occasions where this issue rises up very quickly, and as quickly as it rises, it often disappears off again. It just depends whether there's something that makes people irritated, usually over deportation. Abu Qatada was the classic example. But the irony is that we eventually got rid of Abu Qatada, and not only that, but we significantly changed the Jordanian criminal justice system for the better in order to do it. It was a win-win, even though I think the last Prime Minister failed rather to see that. She always seemed to see the glass half empty, whereas I thought the glass was half full.
Well, thank you very much. Charles Tannock, it's your turn.
Charles? I can see his question. Have we lost him?
Well, Charles, yes, there he is. Yeah. And you need to unmute yourself as well,
yeah.
Charles. Shall I read the question?
Yeah, I think, go ahead.
Okay.
Hang on, can you hear me now?
There
Can you hear me now? Sorry, I think I was muted. First of all, I'm intrigued, Dominic, that you defended HMG, I presume in that rather famous case regarding the Chagosians and the British Indian Ocean territories and Diego Garcia. That must have been quite a difficult one, I think, to defend. But anyway, that's another story. I wanted to say that a lot of people, actually, that I met voted for Brexit, actually, confusingly still thinking that it meant leaving the European Court of Human Rights. And I do fear the day when there will be a judgment which hits the tabloid press and they'll say, well, we thought we'd left Europe and here we are still being run by foreign judges. But I have to confess personally, over the years, I've changed my mind and I am dead against leaving the Council of Europe and the convention, because it would send a terrible signal to other semi-rogue authoritarian states on our continent. I also believe, particularly with my Irish heritage in mind, that the GFA and the confidence that still exists amongst the Catholic population of Northern Ireland is partly supported by the virtue of the fact that both countries are still in the Council of Europe and still subject to the Court of Human Rights. I do believe that if we make that final step, actually resile from the Convention and the jurisdiction of the court, that it will undermine the trust that the Catholics and some of the moderate nationalists have. And I think it'll be the final nail in the coffin for Northern Ireland remaining in the United Kingdom, particularly if the DUP start to get a little bolshy and unpleasant and nasty, and London turns a blind eye towards that sort of behaviour. So if you believe in the United Kingdom as a union, I think actually leaving the ECHR and the Convention could actually undermine that and indeed precipitate a united Ireland.
Yeah, I agree. I think actually if we were to leave the ECHR, and even if we were simply to no longer have the ECHR incorporated into our own domestic law, we would be in breach of the Good Friday Belfast Agreement. The terms are quite clear that one of the undertakings the UK government gave, it was just at the time when we were enacting the Human Rights Act, was that we were adherent to the ECHR and would incorporate it in our own domestic law. So we would breach the Good Friday Agreement totally, and we would pay massive reputational consequences for doing it, quite apart from our relations with Ireland collapsing, and arguably the Good Friday Agreement itself being in danger of collapse. So it's a very bad idea. And of course, that highlights the fact that if we do want to pull out of the ECHR, then just as we've ended up having to do leaving the EU, Northern Ireland would almost certainly have to have a special status where it was still subject to the European Convention on Human Rights and have a Bill of Rights of its own, even though Great Britain didn't. Another nail in the coffin of the Union for those of us who think the Union matters. So I think it would be, from that point of view, a very bad idea. Just can reassure you on the first point that the case I did for the government was not the later case on the British Indian Ocean Territory. It was about maritime fishery rights, although the two were linked. It was the first case where Mauritius argued that the UK couldn't declare a maritime conservation area around the British Indian Ocean Territory because they had reversionary rights over Biot.
Thank you.
Thank you. So, Mark Boliat, your question.
Lost Mark.
You'll know he's coming, and you need to unmute Mark. Yeah.
I've unmuted. Thank you for that. This is not my area, but that was fascinating. Can I follow Charles's point from my Vox Pop, i.e. my golf club? People wanted to leave the European Union to get rid of the European Court of Human Rights. It's an issue on which people feel very strongly, but without knowing why. Two questions. Will we be having exactly the same debate in 10 or 20 years' time? That is, we are still have the same act and we're still in the European, all the European bodies, but there's a strong feeling that we should get out of them. And more widely, is this a sign of the political times that one announces an intention that can never be implemented, and perhaps this keeps everybody, if not happy, then not as unhappy as they might be?
I certainly think it's a sign of the political times. There's been a tradition which I've seen develop and which I've disliked intensely over my time in politics, of more and more of these slightly wild promises being made which never lead anywhere. Now, where I perhaps differ with you is I'm not sure it is all that innocent, because what it tends to do is to bring the institutions of government and parliament into a sort of gentle disrepute. Because rather than being honest with the electorate and saying, we understand that there are some downsides of having this, but there are also upsides, and really we should accept them and we can manage them, we sort of join in the sort of golf club bar grumbling when we don't really intend to carry it through. And I think that's actually quite damaging. So yes, I mean, it's perfectly possible that in 20 years' time, we may still be talking about the same thing without having done anything. Because as I say, ultimately, the Human Rights Act was a piece of minimalism. It's easy to forget that the Labour Party in the period between 1992 and 97 was exploring having a Bill of Rights, something much more impactful on our constitution, including the possibility of having judicial supremacy. And it decided very sensibly to drop all that. And in fairness to Derry Irvine, who crafted, along with Jack Straw, the Human Rights Act, it was intended to be a minimalist document to carry out incorporation of the ECHR in the least interfering way possible. So my ideal would be in 10 and 20 years' time, we still have the HRA and the ECHR and we stop bothering about it. But that may be a little over-optimistic.
Thank you. Thank you very much, Mark and Dominic. Patrick Lowline, it's your turn. Forgive me if I've not pronounced it correctly, but I hope I have.
You've pronounced it perfectly. Thank you. Yeah, no, I would just like to point out that there's a lot of confusion in the debate because there's the Charter of Fundamental Rights of the EU, which is confused with the with the European Convention of Human Rights all the time, and our enemies who would like to abolish the ECHR constantly exploit that division. So I was just wondering if perhaps we should talk a bit more about the fact that we will no longer be bound by the CFR-EU after Brexit is done.
Yes, I agree entirely, Patrick. And one of the interesting things, and it's too early to tell at the moment, is whether, having left the EU, some of the sting about the operation of the ECHR may disappear. Because you're quite right, most of my constituents, in my experience, didn't understand the difference and thought that the European Convention on Human Rights came from the European Union. Of course, there is another issue, which is that a long-term relationship with the European Union, particularly in areas of cooperation over data sharing or justice, is going to be utterly dependent on our being adherent to the ECHR. And one of the rather worrying aspects of the current negotiations seems to be the government's insistence that it will not give an assurance to our EU partners that we will remain ECHR adherent. And that's, I think, going to make achieving agreements in the field of justice and home affairs, which I think are very desirable for us, very difficult. And I really wonder why the government's doing this, because maybe it's worrying too much about the public reaction. But is it a precursor, as Danny and I were discussing earlier, to in fact the government deciding in 3 years' time that the ECHR is going to go? I don't know the answer to that.
Thank you very much indeed. And now we have a question, Dominic, from Isabel Steinmetz.
Hello, good evening. Can you hear me?
Absolutely.
Yep. Yes.
Wonderful, thank you. So my question really is about the issue of sovereignty and enforceability of international judgments. Now, I know that we are focusing on the ECHR here, but my question again would be about Biot. So I don't know if you can read it, but my question was, could you please just comment on the ICJ judgment from last year that Biot should be handed back to Mauritius? Because I mean, I'm hoping that this will still be part of this conversation, because it is a human rights issue in terms of decolonization and the matter of self-determination. And I was just wondering what you would say about the UK's reaction and the lack of credibility given to, because I do feel that the UK's response was simply that, oh, they're just mistaken, and you know, it is a ICJ judgment. So I was just wondering if you can comment on that at all.
I'm slightly wary of an excessive amount of comment on this. One, because although I have looked at the judgment, I haven't studied this subject in enormous depth, although I have had, as in the past, some involvement in it when I was Attorney General. I think there are two distinct issues here, and the problem the United Kingdom has had is that our behaviour towards the Chagossians, and in particular our decision to move them off the archipelago to the Seychelles and Mauritius, and some now live in the United Kingdom, was an outrageous one and taken in circumstances that were utterly indefensible. And its history. It happened in the it happened in at the time when the US was putting in its base, and it should not. But conflating that with Mauritius's claim to Biot is, I think, although I fear that the one often colours the other, and may actually have coloured the view of the International Court of Justice, I am much less convinced about the International Court of Justice's judgment on Mauritius's right to have Biot as it's part of its own sovereign territory. These two places are, as I seem to recall, approximately 2,000 miles apart. And prior to the independence of Mauritius, the management of Biot from the governor of Mauritius was simply a matter of administrative convenience. There is no other causal link between these two places. Now, that may be an argument that the Chagossians should be entitled to a right of self-determination and to have independence within Biot if they were allowed back there. that might, in the context of decolonisation, be a better argument. And it might also be a powerful argument that the UK should allow the Chagossians back into parts of Biot, although there have been lots of arguments about whether that's feasible because of the nature of the archipelago and the ability to live there at anything beyond sustenance levels. And there are some environmental considerations as well, which are very complicated and I won't seek to go into. But I say the trouble is the UK government doesn't have clean hands on this issue. There is a very unfortunate history, but I'm not sure that that actually justifies the decision of the International Court of Justice, or indeed whether it even gave the ICJ jurisdiction. But having said all that, we're going to have to live with the ICJ judgment, and the UK will, as its supporter of the ICJ, have to make some response to it in due course.
Thank you very much. And we've got just time for one more question, Dominic, and it's going to be from Guy Sandhurst. Guy.
Hello, Dominic. Guy here. I think I could pick up a number of problems, but I think the way the problems we've got presentation in now have arisen in part because in the early days post the HRA, the Supreme Court in particular took a very deferential view to the decisions of Strasbourg, doing rather more than simply having regard to its decisions. And secondly, because we have imported the concept of proportionality, which goes much further than the traditional challenges to administrative decisions of irrationality or Wensbury unreasonableness, and so on, and which really mean that you get the feeling, at least I do sometimes, that it's the length of the judge's foot that's being looked at. All right, over to you.
Yes, I think both your points are valid. Just taking the first one, I agree with you. I think our own Supreme Court and the House of Lords, prior to its setting up, went through a period of excessive deference to the European Court of Human Rights. And then it changed. And I think that change came in part, in the early after 2010, when an awareness started to come into the court. Firstly, that it started to look at the jurisprudence of the Court of Human Rights and thought at times it wasn't as good as it should be. And they started to engage in the dialogue, where they was chucking cases back and reinterpreting and not necessarily following the jurisprudence of the Court of Human Rights. I mean, just to take some examples, we had a case on the use of hearsay in our criminal law. The Court of Human Rights applied a rigorous rule, which frankly would have made our trial processes in our criminal courts impossible. And I remember at the time, the then Lord Chief Justice, Lord Judge, saying they just haven't understood how our system works. So instead of going along with it, the Supreme Court batted it back. And actually, in batting it back, it explained how our hearsay rules were compatible with fair trial process, and the court accepted it in another judgment. And we've had a number of those examples. And taking a subject which is now causing quite a lot of trouble, the one about the application of the European Convention on Human Rights to military operations abroad in areas where the United Kingdom may be exercising control, it looked as if we were heading for a conflict and confrontation. But actually, the most recent judgments of the Court of Human Rights and of our own Supreme Court, Hassan and the United Kingdom, and Mohammed Serdar, in the Serdar case, all suggest that in fact you can reconcile the ECHR with the Geneva Conventions, and that's in part been done by UK jurisprudence. We'll have to see the next iteration when the next case comes back from the Court of Human Rights. So I think, in fact, we have made progress in this field. On the second point, you're absolutely right. But then the question I ask is this: would we really be comfortable today with a form of scrutiny of executive decision-making which can sometimes have a profound impact on people's civil liberties, which was simply based on Wednesbury. I think the world's moved on. And of course, there will be purists who say they don't like it. And one of the reasons why the world has moved on has come from the jurisprudence of the European Court of Human Rights. And you're quite right. Proportionality is now a key issue. But having worked with proportionality for 4 years as the Attorney General, trying to make sure that the government always took decisions which would be seen to be proportionate and therefore not be challenged, I didn't find it unworkable. Of course, it can give rise to some really difficult issues. Be interesting to see what happens with the Shamima Begum case when it eventually goes to our own Supreme Court. But if you actually bother to read the judgment of the Court of Appeal, it's much more nuanced and much more understanding of the problems that government has than I think you would necessarily have had 10 or 15 years ago. So the evidence suggests to me that our own domestic judiciary understand very well the problems which the executive has and are in fact far more deferential to executive discretion wherever they can be than they were 10 years ago.
Thank you. I'm going to hand back to you, David. Thank you for Dominic on my behalf for answering all those questions and answering my questions as usual in depth and very interestingly. So, David.
Mine was a good question. It's got a good answer.
It was a good question.
Absolutely. I was about to say I thought that that last answer sort of almost paved the way at some stage, perhaps for a future group discussion about the convention, because I think this idea of judge-led dialogue and the degree to which that influences the jurisprudence of the court is an interesting one. I was also reminded, listening to Isabel, that you know, as is, you know, I used to get all the easy jobs in government, and I do remember last year that, you know, I happened to be the cabinet minister deputed to go and see the Prime Minister of Mauritius when he was in London to talk about the CGE judgment there. But Dominic, as always, a fascinating and very serious-minded survey. I think you were particularly pointed your comments about Northern Ireland, and we know whatever the debate about both the HRA and the convention more generally, I think it's very important to remember that where Northern Ireland is concerned, this is a key element of the Belfast Good Friday Agreement. And it's also worth noting in passing that there's an obligation, I think both the Scotland Act and the Government of Wales Act, that the devolved institutions must comply with human rights, international human rights obligations, and the convention in particular. So that there's a set of issues there that are potentially difficult. And my own view that I think when everyone takes about how important the convention is for the UK, I have, as a Minister for Europe, you know, found that the convention was a really important lever to try to promote reform in the former Yugoslav republics, elsewhere in the Balkans, in Eastern Europe, places like Ukraine and Moldova, where countries had signed up to the convention and they could be held to account there in terms of delivering those principles in practical form within their territories. But thank you again. Could I say in closing that anybody who's not a member of the CGE but would like to join the group or just find out more about it, please do visit our website at conservativegroupforeurope.org.uk. There will be a recording of this webinar made available upon our website as soon as we can get that out. And we will be holding further webinars over the summer. We will circulate details in due course, but I will give you a provisional indication now, since I sort of agreed this today, that on the 20th of August, we hope to have a webinar where we'll be addressed by Norbert Röttgen, MdB, who is the chair of the Foreign Affairs Committee of the Bundestag and a former member of Angela Merkel's cabinet. And I think, Norbert is always fascinating, both on the subject of international affairs of China, Russia, where he takes quite a hawkish stance, certainly on the German spectrum, but also in terms of his analysis of prospects for the rest of the German presidency of the European Union and the future relationship between the European Union and the United Kingdom. So I think that's one to mark provisionally in your diaries, and we will circulate this in due course. But can I say both thank you to Dominic for his presentation and for his answers, and thank you to Danny for sort of some incisive questioning that sort of brought out some of the key issues that we need to be thinking about and discussing when it comes to human rights and the international law. Thank you. I'm going formally now to close the meeting.
Thank you.
Thank you very much.